I'm well. Matt, I've just managed to send the correspondence. It was delayed a little bit because I was distracted by some urgent matters. I'm not sure if you've had an opportunity to read it.
I haven't seen anything you've sent this morning. You said you would send something about 45 minutes. But,
I know, it was only sent like 3 minutes ago.
Sorry, say that again, Shavesh.
It was only sent 3 minutes ago. As I said, I was delayed.
Oh, okay. Yeah. Look, that's fine. It's probably caught like we've got security filters and stuff. It's probably just waiting to pass through. No, so I
Okay.
haven't fit it out our inbox yet, but when it comes, then I let you know.
Okay.
Speaking of, as always, our calls are recorded and filed just in case. So I do need to let you know that before we can continue.
Yeah, that's fine, and I'll
That's just arrived.
yeah, and I'll document the call at my end too.
Of course.
So
The
essentially,
other thing I have to tell you, Shavesh, is I only have about 30 minutes for the call.
yeah, that's fine.
That's fine? Perfect.
Yeah.
Okay, cool. Well, let's get into it. Last time you told me that you're alleged that IBAC was withholding its statutory authority as a bargaining chip in mediation.
Yeah. So
and that it had reopened the investigation without your consent and it was without proper jurisdiction.
yeah.
So what's changed here? What's happening now?
Okay. Could you also open the correspondence that I've sent, just so I can point out some things that'll be easier that way?
Okay, sure. We have a zip file.
No, not the zip folder, just the PDF.
Just the other one? Yeah, sure. Cool. Okay. I've got it open now.
Okay. So I looked up after we spoke. I believe we spoke on Friday, was it?
Yeah, or Thursday, actually, the 20th, I think it was. I double checked. I think it was Thursday after.
Okay, sorry. Yeah, you're right. We did speak on Thursday. So after that, I closely inspected the IBAC Act and the Public Interest Disclosures Act, and I realized that what they had done was actually a criminal offense. So I take you to paragraph in the document. Yes, I'm taking you to paragraph 9 on page 5.
9 on page 5. Yes, of course, yeah.
So essentially, on the 27th of March, actually, let's go to paragraph 7 first. This is page 4.
7 first?
Yeah.
Sure, yeah.
So on the 14th of March, IBAC had communicated its decision to reopen the matters.
Yeah.
And this was done only because they had to file an affidavit on that day. That was the last day. And even before they had actually sent us the correspondence, they had filed an affidavit exhibiting the correspondence that they would soon send us. Okay? Now, that they had done to show that the matter could be mediated.
Okay, yeah.
And that affidavit had been ordered by the court because we were not keen on mediation, and then the court had required them to provide evidence in support of their assertion that mediation was a proper route. So they had provided that letter, which I have provided to you earlier. But basically, it's a letter that says that we have 4 outstanding complaints from you, and it lists the complaints and says that okay. So it says that there were 3 complaints that we had dismissed, and 1 is still pending. We're reopening the 3 complaints as well. Effectively, we are reassessing reopening and reassessing the 3 complaints.
Right. Okay. Sure.
That's the essence of the letter. Now, that letter was then exhibited to an affidavit, affirmed the same day. So that letter was precisely drafted for the purposes of being used as evidence in the affidavit, which was also sworn the same day. And then on the 27th of March, during the hearing, the counsel for IBAC, who I believe has been appointed as a consultant pursuant to the Act, I think it's section 30 something, that allows IBAC to appoint a member of the bar as a consultant on a matter. So Mr. Brereton and others that were present, well, Mr. Brereton was speaking basically. He referred to all those complaints, and the affidavit was filed publicly in a proceeding in which the parties against whom the complaints had been made, they were also defendants. So they received that affidavit.
Sure, okay. And
they did not know about those complaints. Sorry?
I was going to say, just for my benefit, could you explain what that means?
What that means is that they firstly disclosed the complaints that had been made to the IBAC. It's a criminal offense to disclose complaints that are made. It's a separate criminal. I've listed the sections in paragraph 8.5. So sections 40 and 41. So 40 says that I'm just going to bring up the Act literally.
Sure. I'll do the same. So this is the IBAC Act.
IBAC Act, yes. And also the Public Interest Disclosure Act, I will take you to in a second. So first the IBAC Act. Section 40 says unauthorized disclosures of or provision of information. A person who is or was an IBAC officer must not directly or indirectly provide or disclose any information acquired by the person or the IBAC by reason of or in the course of the performance of the duties and functions of or the exercise of powers of the person or the IBAC under the Act or any other act, except, and then basically for the performance of the investigation itself.
Proceedings for an offence or
That's right, a criminal offence. A criminal offence. It's clarified later in the Act that they're non-compellable for civil proceedings, and they don't have to provide any information in relation to civil proceedings. In fact, they have to argue against its provision. And then just bear with me. Section 41 says disclosure or provision of information by the IBAC. If the IBAC considers it appropriate, the IBAC at any time may provide or disclose information, blah, 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 to those bodies. But then I take you to subsection 3 there of 41. The IBAC must not provide or disclose information under subsection 1 that is likely to lead to the identification of a person who has made an accessible disclosure to an entity identified in those sections if the entity is the subject of the accessible disclosure. And this is a criminal offense. This is a criminal offense.
But it is so they've disclosed it to
the LSBC.
What you're arguing. So you're arguing that the entity is disclosed itself because they're named in suit, yes?
That's right. So the LSBC was a party to that proceeding.
Yeah. I see.
They filed the affidavit and gave it to the parties, including the LSBC. They told the LSBC that I had made a complaint, what the complaint was. The LSBC did not know that we had made a complaint against them.
Okay.
And right after that, they basically started taking detrimental action against us. For instance, they issued bankruptcy notices pursuant to orders that were being appealed. And immediately after they came to know about this, and we wrote to the IBAC about that too. And they've taken other adverse actions as well, of which we've notified the IBAC. So they notified the IBAC and the LSP, and they notified Victoria Police, who were also parties through the VGSO, in those proceedings about the complaints that we had made. They basically listed all the complaints that they understood me to have made. Okay. Now, I take you to the Public Interest Disclosures Act. And sections 51 and 52 are the relevant ones there.
Bring it up. Not particularly quick today, but so did you say section 50 and 52?
51 and 52. By the way, you may also want to make note of the sections 47 and 48. So 46, 47, and 48 of the IBAC Act. So 46 says a protected document is a document that may reveal the identity of an informer, or reveal identity of a person who has been summoned by IBAC, and so on and so forth. So basically people that are providing evidence. 47 says protected documents and other things in proceedings, processes, or actions other than criminal proceedings. So this section applies to any legal proceeding other than a criminal proceeding, any proceeding other than a criminal proceeding of any tribunal, authority, or person having power to require the production of documents or the answering of questions other than the Victorian Inspectorate, any other disciplinary process. For all of those processes, a protected person is not compellable to produce or permit inspection of any document or other thing that the protected person has created or that has come into his or her possession or control in the performance of the duties. So it's only in criminal proceedings. It's only in criminal proceedings that there could be any justification, and even then there would be a balancing exercise that the court would have to undertake.
And you're arguing here, since it's a civil proceeding, it wasn't appropriate for them to provide it to the court, or to the LSPC by way of the court. Okay.
Yeah, and by the way, they weren't asked to provide that evidence. They volunteered it, and they did it fraudulently because there was no reason why they would talk about complaints that were made over the course of the year.
Sure, okay, so you don't feel there was a legitimate reason for them to...
No, it wasn't. It wasn't. They wanted to facilitate a mediation so they could privately tell us that they will do some things if we release them from the liability of, the misfeasance claims that we have. And they wanted to do it confidentially so we couldn't use it against them.
Sure, okay. Sure.
Now, with the Public Interest Disclosures Act, it's sections 51, it's sections 52 and 53, sorry. So,
52 and 53.
yeah, section 52 says content of accessible disclosure must not be disclosed. This section applies to a person or body to whom an accessible disclosure has been made, and so on and so. It's basically self-explanatory, the title.
Yeah.
And it's a criminal offense to disclose it. And then 53, identity of person making accessible disclosure must not be disclosed.
Sure.
All right?
Yeah.
So I wrote to the IBAC on Friday at 5:30 p.m. advising them that they had committed or certain persons had committed a criminal offense, and I raised a IBAC complaint against those persons.
Yep.
So this is Ms. Chloe Armstrong and Mr. Brereton and others. You were copied in on that correspondence, so you'll have that. And
Sure, okay, sure.
this was 5:37 on Friday. At 10:30 or 10:26 on Monday, I received 3 notice of assessment outcomes, all dismissing the complaints, all saying that they were basically frivolous complaints that lacked substance or credibility.
Okay.
So what they're trying to do now is argue that they're not assessable complaints.
Sure, that was going to be my next question, because I believe part of your complaint to us was that IBAC didn't find your initial complaint an assessable complaint to meet the threshold in that.
Okay, but here's the thing, Matt.
Sorry, you got.
They reopened the complaints of their own volition, realizing that they shouldn't have done that.
Sure, okay. Do we know that they've opened them under, so are they reinvestigating whether they are public interest complaints then?
Yes, so I've provided you with an affidavit of Ms. Chloe Armstrong, the 14th March affidavit, when on the 20th of 20th of June, but I'm going to quickly read the relevant parts of it,
Okay.
so you get
That
the.
would be great. I confess I've only been able to look
That's okay.
the data you've sent.
Yeah.
I haven't had a chance to go through everything, but if you wouldn't mind reading that.
Yeah, no, that's okay. So what it says is that. So for your information, this is from paragraph 5, she starts identifying the complaints. So she says, on 19 January 22, the first plaintiff made a complaint to the IBAC. And then she says what the complaint was. Then on 8 April 22, IBAC communicated to the first plaintiff that it had dismissed the complaint. Then she exhibits the dismissal letter. Then she says, on 9th October 22, the first plaintiff emailed a bunch of people, including the IBAC. Then the IBAC, she explains that the IBAC wrote back and said that they didn't realize that it was a complaint directed at IBAC, and then I wrote back to say that it was, but basically they had not assessed it. Then she says in paragraph, and then she mentions the other 2 complaints as well. Then she says that we started the proceedings against the IBAC on the 23rd of November, and that they brought a summary dismissal application, and that application was dismissed by Justice Ganay, and His Honor published reasons on the 20th of December. And then she says, this is the most important part. Having regard to the matters identified by the court in its reasons, IBAC has commenced a process of assessing and or reassessing each of the January 22, October 22, and the other October 22, and as well as the July 23 complaints.
Sure.
So they reopened the matter because of their own volition, by the way. I'd never asked them to do that.
Yeah, you just said last time.
In fact, I've always criticized them for doing it because that wasn't the proper way to go. What should have happened is fresh complaints should have been investigated. Because for one, as I've pointed out in today's letter, the problem that they run into is that when the complaints were made, there was very little evidence available and very little, we had little knowledge of all the things that were in play. So the matters that they're investigating came after the complaint. So they're investigating matters that occurred after the complaint had been made.
Right, okay.
Which is an absurdity.
Yeah. I think I understand, yeah.
So, and they have not amended the complaint either. It's not that they've internally passed a motion or anything. I've checked with the investigator. So there is no formal application for the grant of jurisdiction to investigate the 4 things that they are currently investigating. So it's basically...
Because, yeah, okay. So essentially what we're saying here is including things in the complaint that would not, in fact, actually have occurred by the time.
That's right. That's exactly right. So, for instance, the investigator, the fourth allegation that the investigator, this is in the notice of commencement of investigation that IBAC has sent me. They've sent me a letter identifying the allegations that they're investigating. The fourth allegation is about the fraudulent representations that Victoria Police had made during the course of the proceedings. Now, the proceedings hadn't really commenced at that time.
Right, that's it, yeah. So this isn't relating to the stuff that happened before with the audio tapes, it's related to what Victoria Police had done during
Yes.
the court.
Yes. But I mean, what they've done during the court proceedings is quite significant and it needs to be investigated. But the problem is that they used the first complaint because they wanted to deny that they had done the wrong thing in dismissing it. And
I see where your argument is, yeah.
and the irony is that on the 31st of July, the complaint that I had made, even though it was wider than the jurisdiction that they've given to the investigator now, it encompassed those allegations. So what sorry, I'm a little bit impatient, but
No, that's all right. You keep talking. I was only going to confirm what you said, but that's fine. You go.
what I'm saying is that instead of using the 31st of July complaint, and maybe even if they didn't action all of the matters in there, they don't have an obligation to investigate every matter that I raise. They can investigate a small subset of those matters.
Sure, yeah.
But that would have still been, lawful, and unless the refusal to investigate the matter was improper or unreasonable, they could have done that. Now, what they've done now is they've dismissed that complaint, which was valid, and included this matter, and they've reopened the first one, and they've dismissed the July 23 complaint as a complaint that lacks substance, credibility, and is not a public interest complaint, even though it includes the allegations of a complaint that they're already investigating because it's in the public interest to investigate it.
I see. So they're opening one that doesn't include the information that would actually underpin what they're adding to it anyway.
Yes, and they're not using the one that would have made perfect sense, and they've dismissed that one as lacking any credibility and not being in the public interest. I mean, they've just completely messed the whole thing up. You know, there's no single strand of coherence in the whole... Their approach in all of this has been reactionary. You know, I land blows from one side and then they basically change their thing in response. And it's just everything that they've done in this matter has been completely retaliatory. And I mean, the problem is they've messed up in the first instance, and then instead of cutting their losses and owning up to it, they've tried to argue one thing after the other. And I've basically gone after them hard. So, you know, they've gotten cornered. So they're improvising every moment about why they did this or that several years ago. And by the way, attached to the correspondence of today is an affidavit of Ms. Zhu, which was affirmed 4 or 5 days ago. And she had already discussed the matters that had taken place during the mediation. So during the mediation, Mr. Brereton had specifically mentioned what the LSPC had done and how horrendous it was and how understandable it was that I had been offended. In fact,
Sure. And Brereton is the counsel.
counsel, that's right. He was the chair at the mediation on behalf of IBAC. So he's been appointed under the Act as a consultant, is my understanding. They haven't confirmed or denied it yet. They basically, I did request that information, but they didn't, which means that he has been appointed. Otherwise, they would have clarified he's not, because they know that I will add him. So the point is that Mr. Brereton had clarified to us that the complaint against the LSPC was a complaint that was a complaint of an issue that manifested egregious and unconscionable wrongdoing. And I mean, those were not the words that he had used. What he had said specifically was that they can understand why I would be upset about the incident. The LSPC walked in with a journalist, and I said, "Don't call him a journalist." And then they said, "Well, whatever he was," and they recorded the files and so on. In fact, in the proceeding in which that affidavit had been filed, the counsel acting for the commissioner had commented about the LSPC having breached the confidentiality provisions of the uniform law in doing what they've done. He had treated that information, and it's exhibited to the affidavit. But the point is that this is blatantly a reactionary tactic to basically dismiss the complaint that I have made against their staff. So they have destroyed. Well, to be honest, even if they had investigated these matters after reopening them, they would have still been, in my view, unlawful, because they can't revisit the matter. But the point is that they're playing games with the authority that they have, and they closed them not even 2 hours after I sent all of that information.
Yep.
And I mean, if they were, unaccessible, then they should have never been reopened. And even if they were reopened, they were reopened on the 14th of March. So this is like over 3 months after the matters were. Yeah, and by the way, in the Act, there's clear indication that you can't take more than 90 days. Even though, so there's no one section that says that, but it's an implication that arises out of sections 58, 58A, and 58, 58A, and 59. So that division basically talks about the fact that IBAC can only defer complaints of a certain kind, and even those complaints cannot be deferred for more than 90 days. Yeah, those are not complaints that are non-public interest complaints. And
I guess the argument here would be whether they were deferred or closed, but I understand the argument.
No. I'm saying they were reopened on the 14th of March. It's been over 90 days since.
I see. Okay, yeah, so because they've been reopened,
And the other part is this. Technically speaking, what they did was they created a complaint against those agencies and then told them that we had made the complaint. Do you know what I'm saying?
Yeah, you made that clear at the beginning, yeah. So they've told the
No, but it's also the point that we didn't have a live complaint as a matter of law. They manufactured a complaint by saying they're reopening it. So they created a complaint in our name and then told those parties that, by the way, these people are raising this complaint. So those were the matters that I wanted to raise. Now, I know that you have to go in a minute, so I'm gonna.
Yeah, I was gonna say I really hate to cut you off. But
No, I'm done.
You go.
So I've spoken with the investigator as well, and I've told them that we're very interested in cooperating with their effort, and the reason why I'm raising this issue is so the investigation doesn't run into any complications. And I've indicated to them that I'll be happy to make a fresh complaint just around what their purview is, and I can continue suing IBAC about what they're not investigating. But to assist the current investigation, I can do that, or I would be content if they raised an internal motion too. So he has so he's gonna probably look at that at his end, but I guess from here I'll wait for you to tell me if there is any way of expediting this matter, because the other problem we have is that IBAC cannot investigate our complaints at all because of the conflict of interest.
Yeah, okay. Yeah. Write that down. So yeah, you're concerned that they will be able to investigate this essentially against themselves and for their own conduct in relation to them.
In relation to them, mistreating our complaints.
No worries, Shivesh. What I will do is review all the correspondence you sent me, jump on that as soon as I can, and go through that. And I might see a little bit of advice to the other things you told me here and how we go about it. We are currently assisting the matter of both the IBAC and IBAC to whether it brings those ones. So I will go through this. I do apologise, I haven't had a chance to go thoroughly through the documentation yet, but I will do that.
Yeah, and feel free to ask me any, if you or your colleagues have any questions, I'll be happy to address them.
Perfect.
So, can we expect to hear from you next week?
Sorry, I didn't catch you.
Can we expect to hear from you about the response to the queries by next week, perhaps?
Yes, I'm sure. So yeah, I've got them all here. I will follow up on we'll get back to you by latest early next week with an answer to all of those.
Okay, good.
And just to clarify, that won't be the final outcome.
No, I know.
But we'll answer those queries you had.
But including the one about the expedition of this matter as
Yeah, I've added it in here. Yeah.
Okay.
Yeah, perfect.
All right. Thank you.
Okay, Shivesh, as I said, I really do hate to cut you off.
No. I was done.
Let's go.
Yes.
Perfect. Okay.
Thank you.
Have a good day, and I will get back in touch with you as soon as I'm able.
Cheers. Bye.